Good evening, everyone. I'm going to call the August 2025 meeting of the Washington County Quorum Court to order. Welcome everybody here. If you'll join me now, I want to honor our Father and our nation. So if you'll please rise, we're going to do the prayer and pledge. Dear Heavenly Father, we come to you tonight, ask that you be with us in this meeting, that you ask us to open our hearts and our ears and conduct the business for the people of Washington County in the most efficient and effective manner underneath your direction. We ask these things in Jesus' name. Amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all. Now we're going to move on to the adoption of the agenda. Do I have a motion to adopt the agenda? I have a motion by Justice Dennis, second by Justice Lemming. All those in favor? Those opposed? I'm sorry, Justice Rios Stafford. Did you have something before we voted on that? I did not see your mic.
No, I don't know why my mic is on.
I'm so sorry. Okay, good. All right. Any preliminary motions this evening? Justice Dean?
Thank you, Judge. I'd like to make a motion that all ordinances and resolutions be read by title only.
I have a motion to read ordinances and resolutions by title only by Justice Dean. Second by Justice Dennis. All those in favor? Those opposed? Ordinances and resolutions will be read by title only. Item number 5 is a citizen comment period. We have 15 minutes with a 3-minute limit per individual. Citizen comments this evening. Ma'am, if you will, you're going to want to hit that button on the bottom right. There you go.
Okay.
Please state your name and your address for the record.
All right. My name is Laura Villegas, and I live at 5005 Bonita Place in Springdale. I came here today to speak about the importance of professionalism and fairness in how this quorum court conducts the people's business. This body is bound by Robert's Rules of Order for a reason, to ensure that every member has the opportunity to speak, to protect minority voices, and to maintain order and respect in debate. Having open and respectful debate, in other words, also hearing different viewpoints, enables the court to make more informed decisions. It's deeply concerning when members are silenced because someone doesn't like them or doesn't want to hear what they might say. This is not how a deliberative body is meant to function. The role of the chair is not to choose sides, but to be impartial, to uphold the rules, and to ensure that every justice of the peace is treated fairly. When that standard is not met, the integrity of this court suffers. As taxpayers and as a community, we should not have to watch our public meetings descend into personal vendettas and partisan politics. It's beneath the dignity of this office, and it erodes public trust. For members who have not been silenced, this should concern you also, because it could be you next time, and who will speak up for you if that happens. These same courtesies should be extended to members of the public who come to address the court. And I might add here that I personally have been rudely treated by this body several times in the past few years. It is very hurtful, and it was hurtful to those who witnessed it. It's hard to forget. It remains a long time, here and here. It colors my opinion of the court. We can do better, and we must do better. Washington County deserves a quorum court that operates with fairness, decorum, and respect for the democratic process. Thank you.
Thank you. Public comments.
Hello, we are William and Kathleen Monk. Our permanent address is 22470 East War Eagle Road, Springdale, Arkansas, We live and vote in Washington County, Arkansas, not Benton County, not Stone County, Missouri.
We urge you to vote no to repeal ordinance 2023-26.
Thank you.
Hello, my name is Michaela Stevens. My address is 14713 Greenboro Road, Fayetteville, Arkansas, 72704, within Washington County. I'm here to expose and talk about the illegal dirt pit activity at Heritage Farms, 15204 Draper Road, Fayetteville, operated by MMS SWDBA Heritage Farms under Bobby Morris, and who is now tied in business with disgraced Tom Terminella. What Mr. Morris is conducting is a full-scale four-tier quarry operation when he was beholden to only a two-tier 20-acre operation, i.e., he has turned it into a commercial quarry exploiting Arkansas mining law loopholes, wreaking havoc on our community. Understand that I fully understand the Arkansas Open Cut Mining Act and what that allows and doesn't allow. I am not ignorant to state law. What I am is disgusted by the state statutes being written with the ability to loophole and undermine local residents and Arkansas constituents who have actually lived with the repercussions. Photos and videos from August 13th and 14th show phases 3 and 4 escalating. Mr. Morris was given a general use open cut mining permit that must stay below 20 acres. He has escalated dust clouds choking in our air. After Tom Terminella was closed down earlier this week, he moved his equipment right over to Bobby Morris, expanding his operations from a 2-tier to a 3- and 4-tier operation. The increase of community defiance and abuse began directly after Tom Terminella joined forces, after being shut down by local county prosecution by filing an injunction. The days after Terminella's operation shut down, he moved his equipment in. And as I said, I believe this is a violation of his permit, which is a general use permit through the ADEQ. I started a website called ArkansasAgainstEnvironmentalDestruction.com with lots of resources, photos, videos, laws, links, everything regarding this issue. I would also like to bring up the fact that this exact court years ago denied Mr. Morris the CUP permit and this dirt pit quarry years ago. He did appeal that decision. It was denied by the appellate court. He is now trying to appeal to the higher court. Therefore, using the loopholes the ADEQ has allow go on between their Open Mining Permit Act and their ability to ignore local quorum and appellate court divisions. This loophole needs to be closed. He was given a first permit in 2019. He then renewed it last year, and it goes on till 2029. Who knows how many times he will renew this permit and reclamation will begin.
Your time has expired. Your 3 minutes has expired.
Okay, can I say one more thing?
It has to be quick.
Yes. I would like to ask Willie Lemming a question.
That's not quick. I'm so sorry, and you have to address your questions to the chair. I'm sorry. We're going to move on. Next public comment, please.
Okay.
I appreciate it.
You should follow your own quorum court decisions.
Appreciate you. Thank you so much.
Hi, my name is Chris Turpin. I live at 18432 Alexander Road in West Washington County. My JP is Willie Lemming. And I want to comment on the proposed wind farm out our way. We could literally be in the shadow of these 600-foot monstrosities. I have uncovered some information here that might shed some light on the dangers with this. And this is from a report by McCann Appraisal, LLC, based in Chicago, dated June 8, 2010. It was prepared for the Adams County Board in Illinois. And I have a copy of this. If anybody would like one, just holler at me. These are opinions. He's paid for his opinions. He's not for or against him. He's just paid for his opinions. Residential property values are adversely and measurably impacted by close proximity of industrial-scale wind energy turbine projects with value losses up to 2 miles from the nearest turbine. Impacts are most pronounced, number two, impacts are most pronounced within the footprint of such projects, and many ground zero homes, that's us, among many others, have been completely unmarketable, thus depriving many homeowners of reasonable market-based liquidity or pre-existing home equity. Number three, noise and sleep disturbance issues are mostly affecting people within 2 miles of the nearest turbines, 2 miles. And 1 mile distances are commonplace. Number four, real estate sales data typically reveal a range of 25% to approximately 40% of value loss. 25 to 40% of value loss. Some instances, a total loss as measured by abandonment and demolition of homes. Some bought out by wind energy developers and others exhibiting nearly complete loss of marketability. Point number five, serious impact to the use and enjoyment of many homes is an ongoing occurrence, and many people are on record as confirming that they have rented other dwellings to use for nights, especially when noise levels are increased well above ambient background noise and render their existing homes untenable. Now, I'll point out this is 15 years old, and in the 15 ensuing years till now, windmills have gained about 50% in overall height, and they've gained about 100% in generator capacity, the generator on the turbine. Okay, so it's not getting any better.
Thank you, sir. That's your time.
Okay, thank you.
Appreciate you. Public comments.
Hello, everybody. Charles McKinney, 19956 Lakeview Road. I have a question for EcoCrest. Why don't you just fix the issues that prevented you from getting that conditional use permit? Why not just fix them? They're very simple to fix. A septic
Sir,
system,
please
a
take your
fire
seat.
system,
Mr.
fix your
McKinney.
lights, and don't park in my driveway.
Mr. McKinney, please address your comments to the board.
Well, the point is, why doesn't someone ask them? Because they just have to fix the leach lines on their septic system. If they have less than 16 people, they don't need a sprinkler system. They can commit to having less than 16 people. Then move those floodlights out of my bedroom windows and don't let your delivery trucks idle in Mary's driveway. We don't have to go to court for this. It's gonna cost much less just to fix these few things. Don't you think that's a great idea? Aren't you sick of seeing us? Just fix it. They're simple to do, and we'll be done. Now, could they come up and make a commitment to do that tonight and we could all go home early? Thank you.
Thank you, sir. Public comments.
Good evening. My name is Debbie Price. My permanent address is 17718 Bluffview Drive, and I live and I vote in Washington County, and I am now urging you to please vote no to the repeal of Ordinance 2023-26. Thank you.
Thank you, ma'am. Public comments.
Good evening, Justices. My name is Bryson Austin. I live at 808 West Lawson Street. Sorry, I'm still remembering it. I just moved. I am starting a new position and digging a lot more into county work. I've been used to federal, state, and some city work, but now I'm looking more into the county in which I live. And this is actually the first county I voted in, and the first county I paid property taxes in. And digging into some of the ways my property taxes have been used, I've not been too thrilled with a couple decisions from this particular body. Indeed, one of those would be the, I think, $19 million jail that's being built with COVID funds. I think it was smart how that was framed, right? For COVID mitigation, you're gonna need more space, that kind of thing. And so you get to use $19 million of money that was pumped into the economy for recovery after the pandemic and during the pandemic to jail more people. I recently graduated from the University of Arkansas with a degree in economics, And I studied economics and political science while there. And I kind of did that to prove a point. I've always been passionate about political science and politics. I come from a long line of public servants, working for veterans and working in the medical field. So I've spent my entire life around people with disabilities, people in poverty, people that needed help from their government and that needed more assistance, even when the government wasn't listening. And I will say that personally I find it abhorrent to spend $19 million more to jail people instead of preventing the reasons that they get to jail. In my line of work, I work with people that a lot of the community would deem criminals, and some that you would see as unredeemable, but I find them to be immensely amazing human beings who often are trying to turn their lives around and just need the help, and sometimes they get kicked down again. One of my coworkers is actually a person that has been formally involved in the criminal justice system, and I don't think that she ever needed to be in jail. I think that she needed help. And that's something that I think that the CRI is trying to do, but the CRI also segregates a portion of the population when the jail, with over 700 people for Washington County, has already got people that need the help and probably need the programming. And I've seen the maintenance requests and the kind of conditions that are going on down there. And I really would implore you all to take a look at that and maybe rethink how we use some of our tax dollars. Instead of imprisoning people, maybe lift them out of poverty. So yeah, attack poverty, not the poor. Thank you.
Thank you, sir. Public comments. Ladies and gentlemen, we can't have the applause interrupting us. I'm so sorry. Public comments. I have a motion to add 21 minutes to public comments by Justice Lyons, second by Justice Rivera Lopez. All those in favor? Aye. Those opposed? Thank you for the interruption, ma'am. Please proceed.
My name is Nancy Allen, and I live at 17809 Bluffview Drive in Sonora. And I appreciate all of you serving as justices of the peace for Washington County. My husband and I live in the Bluffs subdivision, and we've watched with interest the Eagle Crest situation. If a big business can move into War Eagle Cove neighborhood, could it also happen to our neighborhood? Could it happen to yours? Eagle Crest began operating in 2022 without a conditional use permit, even though the county has an ordinance that states that areas are designated as agricultural and single-family homes. Ordinance 2006-66 defines single-family residential as a dwelling for occupancy as a residence for one family. Eagle Crest is a for-profit business. It is not a family. The clients or their insurance pay a large fee, and then they stay for a while, and then they move on. A family stays together. Eagle Crest was instructed to file for a conditional use permit. The Quorum Court denied their CUP, and yet here we are today. I urge the Washington County Quorum Court to stand by this denial. Eagle Crest is a for-profit business and does not belong in a single-family neighborhood. Thank you.
Thank you, ma'am. Public comments. Ladies and gentlemen, we can't have the interruptions of the applause. I'm sorry. If we can't continue, we're going to invite people to spend their time somewhere else this evening. Could I get us some deputies in here in the back of the room, please? You may continue, ma'am.
Hello, my name is Jan Walker. I'm a sixth-generation Springdale girl. I live at 500 West Lakeview Drive in Springdale. I wanted to tell you my thoughts. Mary McKinney has been a gift to Springdale. She was chosen by Bernice Jones to run the Jones Center. Later, she was in charge of Circle of Life Hospice until her retirement. Mary is a lifelong resident of Springdale. Her father, Charles McKinney, was also the mayor. She's very active in the First United Methodist Church of Springdale, etc., etc., etc. Plus, I grew up across the street from Mary. I've known her always. She's a decent person of kindness, and integrity. People know and respect Mary McKinney. Thank you.
Thank you. Public comments.
My name is Doug Leach. My permanent address is 22649 West War Eagle Road. I live and vote in Washington County. I am asking you to uphold Ordinance 2023-26. This facility is not comparable to a single-family home in operation or impact. Thank you.
Thank you. Public comments.
Hi, I'm Stephanie Foster. I have a home at...
Ms. Foster, will you pull that microphone down closer to your mouth? We have some hard hearing sometimes up on the horseshoe.
Sure. I have a home at 14755 Greenboro Road. So I know exactly what Ms. Stevens was talking about with the illegal mining operations that we have been dealing with for 7 years, fighting. I know that we've been told that this new zoning ordinance, if it passes, would allow the county to then fine companies that are operating even if it's under appeal. I will say that that fine is $1,000 a day, is what's listed in the new ordinance. I don't know what the limitations are, but I will tell you that $1,000 a day will not stop an illegal mining operation. It won't even slow it down. They'll just run a couple more trucks, and there's their fine. So I would encourage you to think about, for these industrial CUPs, if they are operating illegally and fined, that violation needs to be a lot higher if you really want to stop them. Also, you probably need to put some language in there about how they're stopped. What instigates that? Is it neighbor complaints? Is it the county going out and checking on it? How do you know that they are in violation? So I'm also think that the county needs to consider, if we have companies operating illegally in the county, how does a company operating illegally collect and pay taxes to our county and to our state? And that's something we need to consider. Thank you.
Thank you, ma'am. Public comments.
Hello, my name is Tina Lockwood. I live at 22657 Lakeview Road. So I live and vote in Washington County every election. I'm asking you to stand your ground on the original denial. This court did not discriminate and was enforcing uniformly applied common sense rules established to ensure public safety. I want to talk about public safety for a moment to you. When Eagle Crest first moved in, I came in about 2 inches from being tossed down 20-foot ravine from 2 cars driving excessively down that 1-lane road. I saw my life flash before me. Makes me nervous even to this day to even go down that road to visit my neighbors. On July 25th, my husband and I went out on our boat at 7:40 p.m. My neighbor had called me, Miss Mary, and she had told me that she had been verbally accosted by I don't even want to say residents, patients. That's the wrong word for me to use because they're not residents. I'm a resident. They're a patient. They verbally accosted her. We were out on our boat and I noticed trespassing on Mr. McKinney's property. I immediately took a picture and I sent it to Mary and the sheriffs were called. That report has not been released. Judge Deakins, please look into that. Please look into that for us and get that released. It should have been released by now for this date today. As we were sitting there, a fight broke out. Let's say argument, because I didn't actually see a fight, but let's say argument. An argument broke out, a big argument. So much so that all those people that were swimming in and around the lake, in the channel, bobbing their heads around while boats are going by, endangering me as a boat operator, because I could hardly see them, they started screaming and yelling at us because they didn't think that they could see us. That was the first part. The second part was an argument broke out, and they were all told to get out. All they had was a security guard there. No lifeguard, no owner on the dock, which is what the rules are. They must be accompanied by an owner on the dock. These patients could hardly even get out of the water, and we sat there and we videotaped them and watched them because we were worried that they weren't going to be able to get out of that water. I've seen ambulance after fire truck, after chief go to this residence. I can see the road from my house. Lights, middle of the night, 1:30 in the morning, back up, forward, It's a one-lane road. How do you get an engine up and around that corner?
Thank you, ma'am. Public comments.
Diana Scott, 299 North Platinum, Fayetteville. Good evening, Judge. Great turnout. Many important things are going to be addressed apparently on the agenda tonight, and I don't understand why this is not on the agenda. I hope to see it in future. At the last quorum court, there was a passing reference to an issue with the sheriff's department. And I thought, well, what's that about? So I did some research, and it was a very interesting read. Apparently, in January of last year, Justice Lemming brought to your attention an accusation of reports of misuse of county property. In turn, you met with Sheriff Cantrell and Chief Deputy Greg Tabor in February and discussed this. They admitted it was problematic, but they were very dismissive. They said they'd do an internal investigation. Your email says, after several months, my office was still receiving reports and accusations regarding the Sheriff's Department's misuse of property, but now, in addition, the accusations started to grow into incorporate theft of funds in the form of cash, as well as significant personnel matters. I was astonished that a majority of the accusations that we heard regarding the misuse of property were factually substantiated. Additionally, the subsequent allegations involving theft of funds were also substantiated. These are your own words, Judge Deacon. You asked your Chief of Staff, Michael Stewart, to do a follow-up investigation. Among other things, he recommended that the building and grounds maintenance personnel positions and funding for all that are currently assigned to the Sheriff's Office be moved back under the Washington County Buildings and Grounds Department, where they were originally located until they were moved in 2018. I don't know if this court has the jurisdiction to follow up on the supposed malfeasance at the Sheriff's Office, but going forward with the Quorum Court budget, this is something I want you to consider. Thank you.
Thank you. Public comments.
Sherry Main, 15451 Riches Road, Fayetteville. I want to bring up ordinance number, well, it's on the agenda tonight, it doesn't have a number, but it is the ordinance correcting or amending the planning department to add 2 more members to make it 9 members. And I just wanted to give my opinion on this, which whether you want it or not, it's public comment. This ordinance is out of order per ordinance number 2019-04. We either have to go by ordinance number 2019-04 or suspend the rules by a 2/3 vote. And I went back to the Code of Ordinances and pulled up 2019-04, and it's an ordinance amending the Washington County Code Section 233. And this is how ordinances are presented before the Quorum Court. This was signed by Joseph Wood on January the 22nd, 2019. It was introduced as an ordinance by J.P. Patrick Deakins at the time, which is now our county judge. And what this does, it effectively recognizes the need for an efficient manner in which ordinances should be introduced. And it goes on to say that ordinances, a general ordinance not presented to the county attorney by the member of the Quorum Court, introducing the ordinance in rough draft form at least 5 days working days prior to the date of the quorum court meeting at which the member of the quorum court wishes to introduce the ordinance shall be referred to a standing committee. The county attorney shall review the ordinance in rough draft form, proper legal form, prepare it, and then present it 6 days to the quorum court members 6 days before the meeting. Any ordinance that does not comply with the requirements herein shall be deemed to be out of order if presented at a meeting of the quorum court, provided, however, that by a majority, 2/3 vote of the members, not a majority, it's crossed out, of the quorum court, the requirements herein may be suspended. So unless others specified by the sponsor, all ordinances submitted to the quorum court for approval shall be written in the following manner. Title of the ordinance shall include in summary form all actions performed by the ordinance. The current text of any section of code to be amended shall be written in full with amendments included as follows. Language added to the section of code shall be underlined. Language deleted from the section of code shall be struck through. A new section of code to be established shall be written and underlined in full, including any title. A current section of code to be totally repealed shall be written and struck through in full, including any title.
Thank you, ma'am. Public comments.
My approach, if I may approach, I'll give this to Attorney Lester.
Yep, quickly. Yep.
Joe Maynard, Fayetteville, Arkansas. In regards to Eagle Crest, we've got a perfect example of what I'm concerned about. You've got Eagle Crest, who was denied by the planning board. You've got Eagle, and you've got, it was also denied by the quorum court. For good reason, compatibility being just one of them. You've got the Terminella Weddington mine thing that is being persecuted. Maybe it's right, maybe it's wrong, it's your call. But yet we're going to allow another company to operate without a CUP. So that is my fear about this new planning ordinance. You've got these two operations, and both have been rejected as incompatible by the majority of these people in a functional system, which I would add seems to me like it works pretty well. You've got 7 planning members, you've got 15 quorum court members. I believe and respect the judgment of that many people. Putting that power into one person's hand in relative to the fines is going to be done selectively, vindictively, and corruptly, in my view. This just illustrates the problem that's going to be exacerbated by passing of this next ordinance. So I would urge you guys to seriously consider not repealing the ordinance that was voted on by the people and is supported by the rest of the people, the public at large. Also, on the planning ordinance, don't reward dishonesty. It's been changed, it's been adjusted, it's been pushed through here, and it's going to be something we will live to regret in the future.
Public comments.
Good evening. My name is Michelle Barrett, and I'm here to speak on behalf of Eagle Crest. I have worked in the social work field for about 28 years, and I have worked in the drug court field for almost 20. We work closely with Eagle Crest and many other facilities. I think that we really have to consider that somebody has to have these facilities somewhere. They have to exist. And what we know with data to support it is that folks who go into treatment, and we know that not everyone who goes in comes out and stays sober and clean, but when they do, we know that they are paying taxes, we know they're working jobs, we know that they become members of the community that we're proud to have. And without the facilities to help them get there, we're paying more tax dollars to deal with them in the criminal justice system, to deal with them in the medical system. These facilities actually improve our communities. I've got years worth of clients who've been through these types of facilities who you don't even know that you're working next to, who have gotten their lives to a place that no one would expect that they were in a facility like this, that they were ever addicted to meth or heroin or fentanyl. And we need to be cautious as well that we remember that addiction affects all people in all socioeconomic statuses, and that we don't pin a certain type of person as who is living there. I get it, we don't want neighbors that we feel bother us, but I've got neighbors that I don't always like either. So we need to support the idea that we've got to have these types of facilities somewhere in the community. And I've seen before that it becomes, but not in my neighborhood. So where are we going to put them? Thank you.
Thank you. And that concludes citizen comments. With that, we're going to move to the approval of the minutes. The July 17th, 2025 minutes were sent out with the packet. Are there any corrections? If not, I'll entertain a motion to accept those minutes. Motion to accept the minutes by Justice Dean, second by Justice Lyons. All those in favor? Those opposed? The minutes have been accepted. Item number 7 is the County Judge's Report. First and foremost, I want to thank everyone from the Viney Grove Extension Homemaker Club from the 4-H Extension Office. They're so gracious to us. We have a wonderful relationship with the Extension Office and the 4-H clubs, and I just really want to continue to promote that. So really appreciate them making us feel welcome tonight, and they did it tonight when the fair is going on. I'm sure there's other places they'd like to be, so I really appreciate that. The disposal report is in your packet. One of the items I would like to note is the heat. I'm always very complimentary of our men and women in the road department. They've been doing a really astounding job the last couple weeks making up for the spring rains and some of our county road paving projects. And of course, as everyone knows, that heat right now is very intense. And so keep those men and women in your prayers, and we're always trying to keep them hydrated at the county. But really appreciate the effort that those men and women are putting in. Our Emergency Operations Center, one of the things they were doing out in the heat today was asphalting the parking lot for that new facility. And so what I want the taxpayers to know is our road department's going above and beyond to save us money and making sure that that project is frugal. So anytime we can self-perform work like that, we're really happy, and I'm really proud of those people for contributing to the future safety of Washington County. I want everybody to know that we are here. We have this moment. We can see the light at the end of the tunnel. That grand opening will be planned for September 24th at 9 a.m. We invite, of course, all the justices to be there as distinguished guests, but also the public. This is a very exciting moment for Washington County. From this moment forward, after that ribbon cutting, we'll all be safer, and our first responders will have better tools and facilities to serve us. And so I'm extremely proud of that, and I hope all the taxpayers will be proud of that also. The Washington County Fair goes on this evening and this week. If you haven't had the chance to get out there and enjoy yourselves, please consider doing so. It's a wonderful time for our family. I want to give a special thanks and shout out to our wonderful deputies of the Sheriff's Office and also our Department of Emergency Management. That team coordinates with the county fair every year to make sure that that event goes off safely and securely. And I've gotten a lot of compliments walking around the fair and meeting the citizens about those team members. And I just want to say thank you and go ahead and pass forward that compliment that I've gotten from so many people. I also want to congratulate all the youth. That's what the fair is about at the end of the day, is the promotion of our rich ag heritage in this county, and also making sure future generations have access to that heritage and can learn about it. And so very uplifting to be out there. Finally, we need to reset the planning board. On August 5th, Act 519 became effective, and our planning board was thus ruled in violation of that law. That way, we had to cancel all the planning board business for the month of August. We have not had any planning board business. And now we move forward with trying to reset that in a way to be compliant with the law. I have reappointments of Lauren Shackelford, Jay Piercy, Chantel Purrier, Anthony McNutt, Robert Daugherty, and Marla Pearson. Our new appointment is subjected to be Micah Thompson. I believe I emailed you guys his resume earlier today when I had him forward that over. He also adds a few comments to what he believes will make him successful and why he is interested in the planning board. He has 20 years of banking and financing, primarily in construction and land development. He's working with a new company that deals in the challenges of navigating development processes in Northwest Arkansas. He's managed the Community Development Finance Institution. He's a member of he's a Goshen Fire District Director, He's a rural farmer, and he lives outside the unincorporated portions of Goshen. So moved. I have a motion to approve. Do I have a second? Second by Justice Ecke. All those in favor? Those opposed? We have a new planning board, and we will continue with that business. Proper? Okay. We have division of the assembly. All those in favor, please rise. We have a new planning board. Thank you.
Judge, point of order.
Yes, ma'am?
How was it that we did not get to discuss that before we voted on it?
Because it's an appointment. This is how this works.
But remember a few weeks ago when I tried to bring an ordinance to get notification about who you were going to appoint before time?
Mhm.
And we were supposed to be, I never received any notice of any of these people.
Well, they're all reappointments, set one, and I emailed the resume out as soon as I had it today. This is a very fluid situation. I hope you guys can all understand that, and that's what we did. So I look forward to moving forward with the planning board business. Thank you. All right. Item number 8. Counselor, will you read that by title only?
Item 8 is an ordinance repealing ordinance 2023-26.
Any discussion or motions on this ordinance? Justice Lyons?
Thank you, Judge. So I want to address something that's obvious. Septic tank has been brought up, fire code has been brought up, and we've talked about this in several of these meetings. The county does not enforce health code that includes septic tank. The county does not enforce fire code, which is the fire marshal. That's the fire marshal, and the health department enforces those codes. So there's nothing the county can do regarding the septic tank and what may be a problem or not a problem. I understand that they've had reviews. I don't know. I haven't looked at them. Same thing with fire code. That's the fire marshal. That's where those discussions need to go if you have concerns with them, not the county. County cannot do anything about it. There have been a lot of discussions on why we're repealing this or why the ordinance is to repeal this. And primarily, in my view, we are at a very high risk of losing a federal court case that has been brought against the county by that company and cause the county to have to pay out an enormous amount of funds for legal fees and whatever the judge awards. So let's talk about group homes. You know, last week, a citizen talked about they're not a group home and this, that, and the other. And so I went back and reviewed the data, the federal ordinances, and I didn't have to go far. I started with the joint statement of the Department of Housing and Urban Development and the Department of Justice. In that federal document, on page 7, item number 8 is what is a group home within the meaning of the Fair Housing Act. A lot of good information. The one point to highlight is the Fair Housing Act prohibits discrimination on the basis of disability and persons with disabilities having the same Fair Housing Act protections, whether or not their housing is considered a group home. Doesn't matter if they're a group home or not. If they're considered to have disability, which those that are fighting drug and alcohol addiction are, by law, you can't discriminate against them. Doesn't matter if they're in a group home, not in a group home, and quite honestly, in this same paragraph, the term group home does not have any specific legal meaning. So it really doesn't matter. Further down in that section, it states some group homes provide residents with in-home support services of varying types. Group homes, as discussed in this statement, may be opened by individuals or by organizations, both for-profit and not-for-profit. So it doesn't matter how much money they make. It doesn't matter if they're for-profit, commercial industry or not, based on this federal document. You still cannot discriminate against them and because they have disabilities. Further down, group homes includes homes occupied by persons in recovery from alcohol or substance abuse. Like other group homes, homes for persons in recovery are sometimes operated by individuals or organizations, both for-profit and not-for-profit, and support services or supervision are sometimes, but not always, provided. Lastly, in page 8, section 9, the Fair Housing Act prohibits discrimination on the basis of disability and persons with disabilities with the same Fair Housing Act protection, whether or not the housing considered a group home or not. From my view, and what's driving my vote on this tonight, is I disagree we treated them differently, because their view is we treated them differently because we've never required college students, 4 or 5 college students living in a home to get a cup. Well, we all know, and we've discussed this over and over again, the enforcement of our zoning laws is based on complaint. We don't have people that go out and, oh, look, they don't have a cup, we need to go. That's not the way this happens in this county, or any county that I'm aware of, based on complaint. I do not believe, and I have never heard of a complaint being brought to us because we got 5 college students out here living in a home together. Had they, maybe we would have considered it. I don't think we've ever considered it because the complaint never came in. Complaint came in on this organization. We looked at it and made decisions. So I think that argument that they have is ridiculous. But again, I'm not comfortable that a judge won't accept it. My biggest concern is because they are disability, and because in our ordinance that's currently in effect, we don't define the number of people that are not family that can live together and still be considered in the residential area. I think that's the one thing in our ordinance that is a loophole that they get to. And because of that, and because of these sections and the Fair Housing Act, et cetera, and what I've read in there, I think we're gonna lose. And when we lose, we're gonna pay a whole lot of money. And I don't think that's good for Washington County. I don't think that's good for the citizens of Washington County that we would have to pay out those funds for that reason when we have the ability to resolve it here without expending that money. Therefore, I move that we pass this item.
I have a motion to pass item number 8 by Justice Lyons. Do I have a second? I have a second by Justice Rios Stafford. Any further discussion? Justice Pond.
Yes, is there not already something in federal court pertaining to this development or this facility?
Counselor, would you like to answer that question and maybe give a brief of where we're at? Update on the legal? There you go.
Yeah, there's a pending federal court case.
Okay, I'm not gonna have a tendency to do any kind of thing that's going to appear to influence what goes on in a federal court. I'll be abstaining. Thank you.
Justice Bruns?
Thank you, Judge. Well, this whole thing took place before I even got on the court, so I'm getting a lot of the information from the rear end. And at best, I think this body has really messed this up. And I think, not looking for applause, sorry. I think that the best that we could do is do what we've done and follow it until the federal court case is completed and we know what the federal judge wants us to do, not guessing. No offense to you, Mr. Lester, I'm sure with your insights, you know a lot more about it than I do, and I do appreciate that, but I just think we need to wait until they give us direction and they say, you go and you do this. And I find it kind of funny that the people supporting Eagle Crest that I know of haven't even appealed Judge Martin's decision yet. Have they? They have? Yes. Well, then why are we doing this? Why don't we wait until these two decisions are made? Why are we trying to pre-up the judges? I mean, we're putting the cart in front of a horse here. So, you're gonna get a no vote from me.
Justice Dennis?
Thank you, Judge. I'll direct my question to you, but I was looking for Mr. McKinney. Did I understand him correctly to say that if Eagle Crest did two things, he would be satisfied? And I wrote one of them down, was keep the floodlights from shining in his face or his house or his bedroom, I think he said. And then the other one I didn't catch. But if he's willing to do those two things, does that mean the rest of you are going to go along with it? Or, okay, thank you. That's what I was looking for. So you're not willing to work it out. Okay, thank you. Thank you, Judge.
Thank you, sir.
I know that was not appropriate, but I got my answer.
If we don't know where it goes to the chair. Rolls downhill. Justice Messengill?
Yeah, thank you, Judge. So when I read this ordinance, there's a couple of things that disturb me. One statement is, Eagle Crest Recovery should not have been required to apply for a conditional use permit. And then Article 2, Eagle Crest should not be allowed to operate without the requirement of a conditional use permit. When I read those two statements, to me it says that Eagle Crest is special. They don't have to apply, they don't have to follow any rules that apply to every other citizen in the county. And for that reason, I don't think this is right.
Justice Lyons?
I don't necessarily disagree with my colleague, but I think if we wait for the judge to rule, it'll be too late. We will be paying an absorbent amount of money for legal fees and whatever damages they offer, and I'm not willing to take that chance. You know, the whole court thing, it's a gamble, and I'm not willing to gamble that we won't have to pay that when we lose and wait for them to make a ruling.
Justice Rio Stafford?
Thank you, Judge. I've done a lot of reading on this. It's been a tough decision. I tried to put a lot of thought and a lot of research into it. I've been in contact with both sides. I've tried to ask them both tough questions on both sides. I think both sides probably thinks I'm being tough on them, but I'm actually being tough on both sides. I worked for 20 years as a journalist. I tried to ask them both to respond to each other's claims. I've read all the emails that have been sent to us by both sides. I read the federal court injunction that prevents us from enforcing a CUP right now, today, or to issue any other CUP. I've read the 2016 guidance from HUD and the Department of Justice about the Fair Housing Act, the same one that J.P. Lyons quoted from. And I took the time to visit Eagle Crest for myself. When I visited Eagle Crest, what I saw there was a home-like environment. There was a regular kitchen, a regular living room, bedrooms, a regular backyard patio. There were 3 different houses, and it was well kept. And here's where I've landed on this. The federal court has already issued an injunction that prevents us from requiring a conditional use permit for Eagle Crest. Judge Brooks found there is a substantial probability the plaintiff, that's Eagle Crest, will succeed at trial under the Fair Housing Act and the Americans with Disabilities Act. Judge Brooks' injunction lines up with what I learned when I read the federal guidance from HUD and the Department of Justice that was issued in 2016. The guidance says that when people in recovery live together in a home-like setting, it has to be treated as housing for local zoning purposes. It says it doesn't matter that the recovery home is operated by a for-profit business. It doesn't matter how long or short a time that people live there. It doesn't matter if there are support staff or services there. The federal guidance says we still have to treat it as housing. And when it comes to housing, in practice, I have never seen us as a county require CUPs for short-term rentals, for vacation homes, for in-home caregivers, or for roommates living together. Federal law says we can't treat people in recovery different from all those people in those situations. So requiring a CUP in this situation, when we don't require a CUP in all those other situations, would be discrimination. I empathize with the neighbors. I understand the concerns that you guys have. This doesn't mean, if there's no CUP, it doesn't mean that Eagle Crest gets a free pass on safety. Even without the CUP, they still have to follow all the state and federal laws, fire codes, septic, water, building codes, all the other health and safety laws, criminal codes. They all apply just like they do for any other residence. If we repeal this, it's not going to change our zoning laws, it's not going to change our CUP process, it's not going to change our development codes, and it won't create any new precedent that wasn't already in federal law. What it does mean is that we recognize reality. Federal disability protections override local zoning when the two are in conflict, and ignoring that exposes the taxpayers of Washington County to an expensive civil rights lawsuit that we are likely to lose. So I am going to vote yes on this, and my vote tonight is about respecting federal law, protecting the taxpayers, and recognizing the civil rights of people in recovery. Thank you.
Justice Coger?
Thank you. First of all, the injunction was actually an agreed order that was agreed to by the county. So that would seem to indicate that the county could also agree to certain terms if we wanted to in federal court. I'm not talking about the CUP, I'm talking about conditions that the county could set. I support rehab facilities, and I said during this meeting back in 2023 that we could not deny them just based on what the residents going through addiction treatment. However, I do not support just throwing in the towel and allowing them or anyone to operate without planning, oversight, or conditions. We still have zoning laws. I'm afraid that passing this ordinance tonight sets a dangerous precedent. It undermines the planning authority and land use integrity. If we create a carve-out for Eagle Crest, that could open the door to others. For example, I can see people coming and saying, why did they get a pass, but I have to go through CUP? My proposed use is similar in intensity. Why should I be treated differently? The Americans with Disability Act does not mean that Eagle Crest and other facilities like it can just do whatever they want. They still have to follow federal and local laws. I've talked to the neighbors also, and I've visited the facility, and I've met with the owners. I'm going to vote against this tonight. I have one question for Mr. Lester, though, as legal counsel. Mr. Lester, we're voting, if this ordinance before us tonight repeals an ordinance that has already been repealed. How can we do that? How? You said before that it wasn't done correctly, but once an ordinance is repealed, it's gone, correct?
So the initial ordinance that repealed the ordinance for requiring the CUP was overturned by Judge Martin. Judge Martin found that the Quorum Court did not follow the proper procedure because in order to issue that ordinance, it should have gone to the planning board and had a public hearing. So he undid what was done by the Quorum Court, so there was no repeal.
Justice Bruns?
Thank you, sir. I'm not clear, Mr. Lester, on the injunction. Does the injunction, does that give us something we have to follow according to law, or is that a halt until the judge can make a full decision?
The injunction allows Eagle Crest to continue their operation pending a final outcome in this case.
That's what I thought. Okay.
Any further discussion on item number 8? Public comments on item number 8. Oh, Justice Dennis?
thank you for letting me speak a while ago and also again. And I would much rather have a resolution, a compromise, if we could have a compromise. And Mr. McKinney did mention that, so I don't know if that's possible or not. But I will say this, I did go out there and I made my notes, and I'll just share them with you. It was a beautiful place. I thought, my gracious, why did anybody let this go to sale without buying it? I would have bought it. I'd have gone into debt to buy it. It's beautiful. And what it'll turn into, if it doesn't work, it'll turn into a vacation by owner, and it'll be rented out every weekend of the year. And it's just that beautiful. And it was private. There was a code on the gate. You had to wait until someone pushed the code in for you to get in. The ravines were very steep back behind. I would not be able to walk down that ravine and then walk back up that ravine to anybody else's property. Of course, now, there was a day I could have done anything, but it was very steep, very, very steep. It was well taken care of. There was no litter. I saw one piece of trash, one little bitty piece of trash on the ground. And I said, if that's the worst you got, you do a real good job. I asked about the sewer tanks, and I was told that they're pumped twice a year because it's not our responsibility, it's the state's responsibility, but they undoubtedly worked before and they work now. And I asked for records for showing that they were pumped twice a year. If you've got a septic tank being pumped, that's very common on Beaver Lake, but you don't want a lot of it going out into the fields and into the dirt. You want it pumped and taken off. So they were doing that correctly. A food truck came while I was there, and it brought in lunch. Had to have the code punched in for that truck, that delivery truck, to come in. And I noticed that they used what I'd call a minivan. It was just a very small van. They pulled up and they unloaded the food in just a matter of a minute. They met them. Two helpers came out, and the driver got it, and in they went, and back out they came, and then he left while I was still standing there talking, getting ready to leave myself. The neighborhood was very nice. It wasn't as fancy as Eagle Crest property, but at the same time, it was very nice. It wasn't very welcoming, I'll tell you that. It had signs everywhere, don't pull in my driveway. And I thought, and I was a little bit lost even with my GPS, and I thought, don't dare pull in. I'm not normally scared, but I thought, golly, they really don't want you down here. And then I went all the way down to the bottom, and it said the same thing there. It was a commercial building of some sort. I don't know if it was a hotel or what it was, but it had signs, do not enter. Do not enter this driveway. And so I didn't. I just pulled in a little bit and backed out. They had deer in the lot. It was very nice. The whole neighborhood had two fawns in one yard and one fawn and a mother and a doe in the other yard. So it was very nice in that way. One thing they had told me was that the guest, if that's what you'll call them, they spend 6 hours of group counseling. And I thought, well, 6 hours is about what kids do in school for a day. And so they have organized counseling for them during the day. Oh, and I wrote this note down. In the same setup, I would not be nervous living next door because it was private, it was separated. That's my opinion. You've got your opinion, I've got mine. I wouldn't be nervous about it because it was hard for me to get in and hard for me to get out. So, and I was there with a car and planning on driving out, and they let me out. It wasn't like they kept me in, but I couldn't have just gone and got in the car and drove off. I had to get help getting out. They had to push the number in. So those were my comments. That's what I saw. I just can't go against federal Disability Act, you know, I made the comment whenever we first had this, I said, this is just a lawsuit waiting to happen. And it is. We get sued either way. We get sued by the federal government or we get sued by y'all. And it's gonna cost the county a lot of money, probably either way. And it's not the way I wanna see money spent, but you know, I would hope you'd, since you said that you would accept some changes, I wish you would accept those changes and let us move on. But if not, it's the hard way. So thank you.
Thank you, Justice Dennis. I will also have Justice Ecke.
Thank you, Judge. I have a question, if I may direct it to Counselor Luster. I really would like for you to share with this court the probable outcome along with the dollar figure of if we were to vote this down and not repeal it, what is the legal fallout to all of this with Judge Brooks's office that we did not resolve this on our own? And how much is it going to cost the county for legal counsel? What's the fallout on that?
I don't know what the dollar amount is. And that comes down to attorney's fees, possibly. I mean, that's up to the court. I don't know that there's a fallout from the judge if we don't, I don't know what you mean by don't resolve this. The issue is whether or not we have violated the Fair Housing Act and the Americans with Disability Act. And that's what the court has to consider based on our decision, is
So
whether we violated that.
That's what I'm saying. If we were to vote to repeal this or not to repeal this, we are in violation of, could you please state that again?
The Americans with Disability Act and the Fair Housing Act. If we vote to repeal this, then there is no case. There's the federal lawsuit will go away.
Okay.
If we don't, the federal lawsuit will continue, and we will find out our fate sometime after the first, I think it's, the trial on this is set for February of 2026.
In Judge Brooks's
in Judge Brooks's court.
Court.
Yes.
So the question is whether or not we want to be in violation of federal injunctions and law or not. This is a conundrum for me. This is tough. I thank you for your counsel.
You know, essentially, it's a layman's, I can maybe put this in layman's terms. We've been given a small reprieve here from the federal court through this agreed upon injunction. And what they've told us is if this resolves, the trial goes away. But if we do not resolve it, then what we're communicating to the court is we're comfortable in our position and we want to proceed to trial, which I believe Judge Brooks commented on, the likelihood of what that would be if we go to trial. Resolve would be a yes vote to repeal the ordinance. That's correct, right? Okay. A yes vote would repeal the ordinance, and we would not be going to trial. Does that make sense? Now I feel like I'm making this muddy, right? Yes. Justice Ecke, did that help a little bit? I mean, we've been given a timeout essentially, and once again, this is my layman's, non-counsel. We've been given a timeout to see if we can resolve it. If not, we're going to trial. With, I believe the quote was, substantially probable that we will, if we move forward. I believe Justice Real Stafford, will you repeat that? Do you have that quote referenced? Will you repeat that again?
I do. This is from Judge Brooks' injunction. It says the court concludes that there is a substantial probability that the plaintiff, which is Eagle Crest, will succeed at trial.
Justice Ecke?
Thank you for having that. I didn't have all of that information. That's tough when a federal judge, tells you you're going to lose. And if you can prove that if somebody can prove, Judge, that this is not what Judge Brooks quoted in this injunction, then I guess the citizens have that opportunity to do so. But when the judge himself says this, that you're going to lose and it's going to cost you all a lot of money, which we don't have to lose, is hard. That's a conundrum I believe I'm in. Thank you.
Are we ready for public comments? Mr. Zaga, thank you for being patient to let the justices finish up their comments, but will you push that button on the bottom right? We'll get you activated.
Thank you, Judge.
Thanks,
Thank you,
sir.
Justices. Steve Zaga, 2377 North Waterway Drive, Fayetteville, Arkansas, in Washington County. I'm an attorney. I represent Charles and Mary McKinney. One thing, I had 3 points to make, and each of you, there have been justices who made all 3 points. I'm going to come back to them, but I'd like you to consider this about the injunction. It was agreed to about 10 days after the lawsuit was filed without the presentation of any evidence. So the county stipulated to that injunction with Eagle Crest. I contend that those questions have not been litigated, not really. So that said, 3 points I want to make to you tonight, and some of them have already been made, but I feel like I need to distill them. One, the language in this ordinance matters. This ordinance says that Eagle Crest Recovery shall be allowed to operate with the requirement of a conditional use permit. In one sentence, you name a private party, you acknowledge that this court and this county has a requirement for conditional use permits, and then you say, these folks don't have to do that. That is the definition of special legislation, ladies and gentlemen, and in my opinion, it's illegal. 2, you may very well solve the federal litigation if you pass this ordinance tonight. I'm not going to argue that point. But what you reward, you get more of. The next Eagle Crest that comes along, the next developer, the next landowner that doesn't like what you do, or you don't do what they like, is going to sue you. And why is that? Because tonight you've told them that if they litigate against you, you're going to change your mind. Any parent who's had a kid in the Walmart aisle going for the candy knows if you give them the candy when they throw a fit, they're going to throw a fit the next time. What you reward, you get more of. So maybe you solve this lawsuit, be prepared for the avalanche that comes later. 3rd, forget the legalities for a second. What are you going to tell, as a legislator, the next developer who comes along and asks you, why should I comply with your zoning and land use ordinances? You didn't make Eagle Crest do it. Are you going to say, well, they were different. Here's all the reasons they were different. Maybe that works. I suspect it won't. I suspect it will not be a satisfactory answer to those folks. Ladies and gentlemen, this is a bad ordinance. It is a private favor masquerading as public policy, and I encourage you to vote no. Thank you.
Public comments.
Yeah, as I said earlier, the planning board did not deny this for handicapped reasons, or it was a very reasonable denial, just like a storage building. It's not compatible with the neighborhood. Just this operation is not compatible. That being said, I do want some clarification for the record, if you don't mind, is what is the statute ordinance, or is it just magic that we have the authority to reconstitute the planning board?
Mr. Maynard, this is an opportunity for you to give us your comments on the ordinance in front of us.
Oh, yeah.
If
So
you have
don't
other
one.
questions, let us know. And we'll
Yeah,
email
I
you.
got it. We'll get it.
Public comments.
Thank you, Quorum Court members. My name is Seth Haynes. I represent Eagle Crest. I think we've cleared up why we're here. I think we've cleared up the history that kind of got us here tonight, so I won't belabor the point. I do want to make a couple of points. One, the residents at Eagle Crest, they have completed the detoxification period of their treatment, and they are simply there to solidify their recovery story. This is a human dignity that we allow people, as a matter of public policy, to solidify their recovery stories, and that's what they're doing out at Eagle Crest. I'd like to respond quickly to Mr. Zega's comments about this being special legislation. That is not the fact. This is not special legislation. This is actually, the repeal of the ordinance actually does what federal law requires it to do. Justice Lyons gave a very good outline of the law. I'm going to quote from the same joint statement from the Department of Housing and Urban Development, the November 10th, 2016. I urge you to read it carefully, word for word. There is no doubt that the FHA and the ADA includes those who are recovery. They're disabled people. There is no doubt that federal law preempts local zoning laws. That is not in question. A land use or zoning practice may be intentionally discriminatory even if there's no personal bias or animus on the part of any individual government officials. That's on page 3 of that report. This directly undercuts comments you may have heard earlier today, that if you pass this original ordinance without animus or bias, that it was okay. That is not the case. That is not the law. Even absent a discriminatory intent, state or local governments may be liable under the Act for land use or zoning laws or practices that have an unjustified discriminatory intent because of protected characteristics. Again, this is likely not what you've heard before, but that is the law. The Fair Housing Act, the ADA, particularly give the ability for us to have a reasonable accommodation for those who have disabilities. This is not about special legislation. This is simply saying the law requires that those with disabilities have the opportunity to enjoy fair housing just like everyone else, and that you have to give them a reasonable accommodation if that's a potential. This is not the quarry issue that we've heard so much about. There's not another developer who can come up and say, hey, I want to do an apartment complex, or I want to do this, or I want to do that. And so you didn't make Eagle Crest get some sort of a CUP. They don't have the same requirements under the ADA. So I would urge you to go ahead and vote yes for the repeal of this to comply with the FHA and the ADA.
Thank you, Councilor.
Thank you.
Public comment.
My name is Mary McKinney. I live at 19980 Lakeview Road. You know, the whole problem I've had with this from the very beginning is the lack of integrity. The lack of integrity from the property owner, Christopher Conway, told many untruths through this. Eagle Crest CEO, Hernandez, told many untruths. In a deposition, Julie Hernandez, the COO, told many untruths. I have a major problem with the fact that your chief executive of your county has not disclosed his conflict of interest in this. I've given him every opportunity to do it himself, and he hasn't done it. He worked for RMP law firm. The problem I have with this whole thing is integrity, lack of integrity. I am not a discriminatory person. Surely you've surfed my social media. Surely you know my professional careers. They have been of the utmost of service to the community and helping people have good lives. It's a beautiful campus. I don't disagree with you, Mr. Dennis. But did you look and see if it's sprinkled? No. So it's a great, beautiful campus. Great. 25 grand a month to stay there. But they're putting their clients and their patients in jeopardy and in risk. Now, if you go back and you do a timeline of the district court cases, what's happened here is your judge and your county attorney have boxed themselves in a corner, and they got to get out of it. It has already been admitted guilt in that federal case if you read it. It's a temporary injunction. It does not keep you from any further action. It's a temporary injunction. You look at the timeline, lay it all out. Your chief executive and your county attorney My problem is a lack of dang integrity. That's my whole problem. I have no problem with helping people. I'm not afraid of the people that are being served there. I am grateful for the service. But I want them to be in a safe environment. I don't want them swimming in the middle of the lake without life jackets, a 300-pound man. I don't want to be called the bitch across the street who's afraid of addicts from the lake. I don't want that. I want some integrity. Yeah, you know what? You are going to lose this federal case. If your county attorney litigates it, there is no doubt in my mind, because he's already made his mind up, and so has your judge. I'm asking for a just decision. I'm asking you put some money up for this, and I agree. I am never going to argue that they are not a protected class. Amen, and praise God for the service that these people provide. But y'all need to recognize what's going on here. This smelled from the beginning, and it still smells.
Thank you, ma'am. Public comments.
Kenneth Lovett, Fayetteville, Arkansas. What is the purpose of y'all being here? Y'all were voted on by the people. These people pay taxes. These people are here to see the right thing done. I think it should be done, and I think you need to listen to these people. Thank you.
Thank you. Public comments.
My name is Stacy Bennett, and I live at 19980 Lakeview Road. In terms of addiction, I'm no stranger. Some might even say that we've been lifelong friends. Whether it be personal or family member or someone else we love, I'd say most of us have experienced on some level the pain and destruction addiction brings. My point is the absurdity of a discrimination accusation against myself and my neighbors frankly turns my stomach. We must all believe that Eagle Crest temporary residents have but one common goal: to get well and go home. When a case goes before a judge, the plaintiffs bear the burden in presenting evidence of discrimination. The court does not assume it for them. At this point, no such evidence has been established, and you have no way of knowing that it will. But rather than require this burden, the county instead chose to ask the legislative branch to just admit it engaged in illegal activity. And you instantly chose this path based upon the promise that a potential federal lawsuit would go away. Therefore, ordinance, that's not been 3 minutes, I can tell you that
It's
right
the total of 12, so we still have an alarm for that one. So
I'd
sorry
like
about
to
that.
finish.
Motion to extend, we have to have an exact time. 2 minutes? 2 minutes? Is that sufficient?
That's sufficient, thank you.
All those in favor? Those opposed? Please continue, ma'am.
When you chose this path, Ordinance 2024-36 was adopted. It also, your vote to repeal the ordinance is your full admission that you had discriminatory intent in enforcing the county zoning laws as they apply to Eagle Crest. It also implies that even if you believed in the original ordinance was fair and reasonable, you were willing to reverse it without even considering consulting a neutral land use attorney or someone with ADA, FDA experience, nor requesting evidence of discrimination. In my book, if you acted with discriminatory intent in 2023, that's one strike. And if you react in 2024 solely at the advice of the county attorney and nothing more, that's 2 strikes. By reacting in this way, you risk rendering yourselves ineffective and failing the very people you were elected to serve. And I refuse to believe that this was your intent when you sought this office. I'm respectfully asking you and everyone else who is here who can stand up, please do not let this happen.
Thank you. All right. That's the end of public comments. I have a motion to pass item 8.1 by Justice Lyons, a second by Justice Rios Stafford. Mr. Allen, will you please call the roll?
Justice Koger? No. Justice Dennis? Yes. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? No. Justice Ricker? No. Justice Pond? Abstain. Justice Bruns? No. Justice Wilson? Yes. Justice Massengill? No. Justice Rivera Lopez? No. Justice Lyons? Yes. Justice Ecke? No. Justice Dean? No. Justice Washington? No.
Item 8.1 fails. All right. We're going to move on to item number 9. Counselor, will you read that by title only? All right, we'll continue. Counselor, will you read item 9.1 by title only?
An ordinance creating new planning and zoning law in Washington County and for other matters pertaining thereto.
Justice Lyons?
Thank you, Judge. Mr. Allen, can you bring up that page, please? So the page you're looking at is what's codified into our ordinance today. As you'll notice in the bottom, there are 51 links referencing all the ordinances that makes up the zoning code that we all abide by and that we all are voting on based on, CUPs are this process, the planning is this process, the backfills and roads and everything else. You got to go through and click every one of these links to find what you're wanting to find and understand the zoning laws. It's very unorganized, very difficult for anybody, citizens and elected officials alike, to really understand this and to get an understanding of it. This ordinance that's in front of us today for third reading, which will be voted on, is basically taking every one of those, and by the way, that's just the first one. If you continue through this, there's a whole lot of other links in here. So there's more than 51 links to other ordinances to understand our zoning ordinances for this county. All this does, as it sits today, going through a whole long months, 9, 10, 12 months, started in one form, that stopped. We redone it to just do what we have today in code in one ordinance. So it's easy to find, it's easy to understand, or easier. There's still some problems with it, but it's easier to find, easier to understand what's required of you to go through the planning process, get to the CUP process, what are the specifications that you have to follow, that you must meet, et cetera, all in one document. Yeah, it's a long document, it's a big document, but it's in one. This is much more difficult, I think, to truly understand that. This is what's in front of you. A few changes, like the territorial, we made changes to this to be compliant with the state law for the territorial area, so that it would be compliant with that, right? But it's basically there. It follows the same CUP process we just talked about that we've been doing for, what, Counselor, up 10 years, right? No difference. And it's taken us a long time just to get what we have codified today and what we follow today in a single document to make it easier for residents to understand what those specifications are and what you need to follow and what the process is into one document, making that all much easier for all the citizens, all of those that want to get a cup, all those that want to build, that want to grow in this county, to understand what they need to do and go through that process. We need to pass this. We need to get on with business. We need to pass this, get on, and then come back and look at it and see what other things we may need to change to make it even more simpler, more organized, to make it more understanding. But we need to get something in place that's easier than what we have today. I won't say it's the end all, but it's easier than what we have today, so that we can move on with planning business. The planning board's now being reestablished, so we can start hearing those cups, those setbacks, those variances, all those things again, and get on with county planning business again. And then come back around, look at it, and see what else we need to do. Because this isn't the end all. This county's growing. We can't continue to do zoning in this manner and grow like we are. It will be a problem. It will cost us significantly more money to follow this ordinance in that growth, to make sure the infrastructure is in place to support those commercial businesses that want to go up. And we need to figure out how we resolve that. So we got a lot more discussion after this, but this is the starting point. I think this needs to be passed. I think we need to move forward with it and then come back around and start working with a number of other things we need to address in it. Clean it up. I mean, I was with another colleague, and he made a statement that it's just unorganized. It is. It's still unorganized, but it's a lot better than this. So let's take the first win, get it better understood, better used by the citizens and those that want to build and need a cup, and then let's come back around and figure out what the next step is. And the next step may be a simple one to make it more organized so you can find stuff easier, or a number of different things, all the way up to what should we be doing to make sure this county can grow efficiently, effectively, and without killing our budgets. So I move that we pass this tonight.
I have a motion to pass by Justice Lyons, item 9.1, and I heard second by Justice Ecke. Justice Bruns?
Yes, sir. I think it was J.P. Lemming that about 3 months ago, the last time we had this document before us, and we talked about 284 pages and all this stuff. I think I heard him ask that the next time this document came before us, if it did, on a vote, that he wanted to see the document in full form of how we're going to put it in the books. And isn't that true, I think? Okay. Well, my question is, I don't know if you all have reviewed this that much, but I can go to the Jim Rollins School of Innovation and ask the third grade class to come up and do something better organized than this thing. This is just a conglomeration of a bunch of forms that's just put together. We need to have indexes. We need to have things easy for developers and builders to find, or they're just going to throw it on a table somewhere and discard it and do what they want to do. Now, I will say this. I think we've done a good job of going around the horn and getting back and putting content, and I'm satisfied with the content, like J.P. Lyons said. I'm satisfied with the content today. Yes, I think we can improve it, but this thing is so disorganized that, and I'm afraid if we just pass it the way it is, we're just going to put it on a shelf somewhere.
No.
Yes, sir.
Let me, one of the things we're extremely excited about if we get this passed is that the Association of Arkansas Counties does our codifications for us.
Does your what?
The codifications, to do exactly what you're saying, to index it. And the counselor can talk more about this if he wants to, but they do that for us. It's a service that they provide. Before that, we had an outside contractor that did service, and it's very expensive. The reason we haven't been able to codify this current ordinance is because of what Justice Lyons was referencing on this screen up here. Is because over the course of history, and Counselor once again can address this more, we were not amending our ordinances correctly. We were amending, this gets complicated, this is kind of splitting hairs. We were amending the codified section, and that's not what you're supposed to do. You're supposed to amend the ordinances, once again, this man going, but we're extremely excited that if we get this passed, we want to get this instantly sent down to AAC and get it codified. And it will have the indexes, hyperlinks, it'll be all digital. So this is just, the paper copy is just a working document that we, of course, have just been, working through with you guys. But we are very excited to get that codified for the very developers and the public that you're talking about, so they don't have to go individually to these hyperlinks. They can search it, they can view it like any normal document we're used to now.
Well, that's easy to do when you got 3 pages like the old CUP was. This is just a little bit longer than 3 pages.
Our CUP process was all of those up there, all those hyperlinks he was saying. So we've consolidated over 50 ordinances. We think it's more, over 100 ordinances into that one document.
And that's what we're looking at today.
That's what we're looking at. What you have in your hands and what you have before you, and I want the citizens to understand this too, is a consolidation of what we're currently doing. The benefit we're going to get out of you passing this tonight is some of the stipulations that Justice Lyons talked about with the increased penalties and some updates in the code and all that. But essentially what it does is just consolidate what we're doing to one ordinance, one document that we can get it codified. The public access and the developer access to this document is very much something that we are pursuing very hard. We are excited to get that done.
Do we have a timeline when we can get this done?
I'm not sure. We haven't spoken specifically with the AAC about that.
Can we do that and then update this court?
Yeah, absolutely.
Because, this thing's a mess. It's just real hard to, I've been over it 20 times and it's hard for me to find stuff.
I agree with you, but the bigger mess is up there on that screen.
Yeah.
And that's what we've left people with to this point. If we could pass this tonight, it would be overwhelmingly positive for everybody in this county. I cannot think of someone, unless we change our code, our planning process drastically. This improves everything for everybody, whether you're talking about a neighbor, an applicant, anybody can go to this code and read it much easier. This is going to be a benefit for everyone if we can consolidate this, simplify it, and get it codified.
Well, Judge, the quicker we can get it collated and back to the people that actually do the grunt work, the better off we're going to be.
I have agreed with that statement for over a year now.
Thank you.
Justice Dennis?
I apologize to the court right away for taking so long, because I'm going to take a minute or two, but part of this comes from the recent lawsuit or deposition we had to do, and so I'll make my feelings known, even though I know how I'm going to vote. But on what I hear from everybody is I want to be able to do what I want with my property. And currently you cannot do what you want with your property because it affects your other neighbors, and the only time you have some of that you can do is unless it is agriculture or residential. And even then you cannot do anything that you want. If you want to put in a wedding chapel into a church building that has disbanded and put it up for sale, and you bought it, currently you have to get permission from the city or the county that it is located in. You have to be able to, in order to operate it. Also, you will, I apologize, someone decided they'd butt into my conversation there. Plays my hearing aids. But anyway, so if a church building that has been disabled and put up for sale, and you buy it, you currently have to get permission from the city or the county that it is located in. You have to be able to operate it. Also, you will be forced to pay property taxes on a building that has not paid taxes in the past 123 years. And the only difference in the new zoning is the process has been simplified, and you will not have to go through a complicated process. The end results are the same. My wedding chapel that I bought from a church, I pay sales tax, I pay property taxes, I pay personal property taxes on it, I pay the same taxes on utilities as a commercial business. I have to have fire inspection twice a year. I have to pay for the equipment if they say I need more equipment for the fire equipment or for the fire safety. If I expand with a building for a reception, I will have to put in a paid parking lot with all the above taxes added to it. So doing what you want with your property still comes with restrictions, and having those spelled out will help people know that going out in the county will come with some restrictions. That should be spelled out before you buy and build. Therefore, the new zoning is fair and open, and what is good for one is good for the all. So I'm for it. I think that it would simplify my job if I was buying a new business or building a new business. I would know up front what it's going to cost me. And also, I think the things that I have seen is if you have rules, you can enforce them. Most of our rules are, if you drive the 49, which we all do, and the speed limit is 70, you're obstructing traffic. And yet the speed limit on a lot of it is 65. And so I see cars driving 90 miles an hour all the time. Well, they don't enforce it. They don't enforce it. They don't pull people over. Some they do, but you can't pull everybody over. And people still speed. Well, if people want to do what's right when they build, they'll follow the rules. If they don't want to do it, then you do. You catch them sometimes, and sometimes you don't catch them. But at least we've got rules that say, and we've got zoning rules that say, this is what you have to do. And it's plain and simple, and it shows you what you've got to do. It's not a surprise for anyone that wants to be in business. So I'm for it for that reason. I don't think it's taken away. I think it's actually making it more simple to do business in Washington County. Thank you.
Justice Rio Stafford?
Thank you, Judge. Buckle in, because I've got another speech written for this one. Because I want to explain, we've been going around this for 17 months. It's very different from where we started 17 months ago, and I want to explain why I'm voting the way I'm voting. So this is some reasons why. Number one, it's going to help us crack down on rogue dirt mines. Right now, our zoning rules, they're hard to enforce. We have $250 a day fines, but those fines are suspended if something's under appeal. That is a loophole, and that has allowed folks like rogue dirt mine operators to game the system by just filing appeal after appeal after appeal through the system while they just keep operating with impunity. This would take away the suspension. The fines would go up to $1,000 a day, and they'd keep going, even when things are under appeal. It fixes legal loopholes. The county judge just talked about one of those. Some of the ordinances that were passed decades ago, I don't know why they did it the way they did it, but they didn't do some of them right. And so that could put some of our planning ordinances in legal jeopardy if they ever get challenged in court. So passing them, even though they're written exactly the same word for word, passing them all over again in the right way is going to help us cross our T's and dot our I's to prevent things getting overturned that we don't want to get overturned. We've also changed the definition of single family in this because, in the middle of this whole thing with Eagle Crest, I think it was vague. It could have been seen as discriminatory. We changed the definition of single family to focus on occupancy, a maximum of 2 individuals per bedroom that matches the guidelines from HUD. Since we've been going through all this, the state legislature, they went through an entire session. They started and ended. They're already done. They went home months ago. But one of the things, and the stuff that they passed has already gone into effect as of August 5th. That's how long we've been going through this. But they changed the law since we started this process. And so we've had to make amendments to catch up with that. They got rid of territorial jurisdictions, the Arkansas legislature did. So we had to amend this whole thing to get rid of territorial jurisdictions and assign all those planning responsibilities that where cities used to have some jurisdiction outside of their city limits. Now that responsibility falls to us. So without passing this ordinance, or our current planning codes are outdated. So we need to pass this in order to stay current. As JP Lyons pointed out, it puts everything all in one place. You can see this crazy spaghetti code up on the screen up here. It's ridiculous. It may not be the clearest document, but it's better than that. I prefer this over that. Two things it doesn't do. It doesn't change anybody's zoning, if you're not up to speed on that. Months ago, we removed the commercial zoning. We removed the industrial zoning. Everything is going to be exactly the way it was in terms of, our county being residential, agricultural, low density by right, and everything else is going to require a CUP, the same way we've done it since 2006. It doesn't give any new powers to the county judge. No offense, county judge, but a lot of people have misunderstandings about this. We have the exact same appeals process that we've had since 1991. Nothing about this has changed. Land development appeals, there's a step in there. At some point back in the 90s, for whatever reason, way back then, they decided that the county judge was going to hear land development appeals from decisions of the planning board. Those are extremely rare. We've only had one of those since the year 2021. But we've had that in place since 1991, and it hasn't changed. The CUP appeals, they're still going to come to us. That's not changing either. Some people have criticized the process, and I think rightly, for not having a public town hall where people can actually ask Q&A. We've had a lot of public comment, but our process here is people come up and speak, and it's not a back and forth. It's not a thing where you can ask questions. I think we should have had that. I agree with that. And I think that's one of the reasons why misinformation has been allowed to run rampant about this ordinance. There's been a lot of misinformation about it. And I think when we go forward making changes, big changes to this, we should have that. But basically, the bottom line is that all the controversial stuff that people have been coming to us with is gone. It's out of this. There's no commercial zoning. The zoning map doesn't change. It's going to help us crack down on violators. It doesn't give any new powers to the county judge. And I'm ready to vote yes on this. Thank you.
Thank you, Justice Real Stafford. Justice Coger.
Yes, thank you, Judge. I'd also like to explain how I feel about this ordinance and some concerns that I have. First off, on page 10, where we do away with competitive bidding for building contractors. I don't think that should be in here. I don't think it's needed. It doesn't go along with the zoning. On page 66, where we talk about the zoning map is being attached, but it's not referenced by a book and page, so that doesn't really tie it down. That concerns me a bit. But also, one thing in the ordinance that really bothers me is that we're shifting the responsibility of who gives notice to landowners. We're shifting that from the county to the developers. And I don't think we should be doing that, because I think that's a due process that the county should see. And if it means that we have to hire more planning staff in order to do that, then I would be for doing that. Then the thing, starting on page 46, and to address some of the things that some of my colleagues have said, that yes, the way some of these appeals have been, they've been in the ordinance. We've been doing them this way for a long time, but that doesn't make them right. That doesn't mean that we just have to continue doing them that way. For instance, on page 46, section C, the county judge may waive the above appeal requirements. However, the county judge's decision is final. Nowhere in state law is there a provision for the county judge to be given final authority on any appeal from the Planning Commission. This ordinance establishes an appeal process that centralizes excessive authority in the office of the county judge. So what if it's already been there, he's already been doing these things? That doesn't make it right, and that doesn't mean we should do it going forward. All appeals from the planning board decision under this section that I'm talking about, and the county road superintendent decisions are directed solely to the county judge. No independent review board, no quorum court oversight, and no higher appeal mechanism exists in the ordinance. The county judge appoints the planning board, the planning director, and the county road superintendent, the same officials whose decisions may be appealed. The judge then acts as the final authority to affirm, modify, reverse, or waive requirements related to those decisions. This ordinance grants the county judge the power to waive appeal requirements altogether and states again that the judge's decision is final. In comparison, I checked in Pulaski County, all appeals from the planning board there go straight to the circuit court. Benton County has a 7-member board of appeals, separate from the planning board and separate from the zoning board of adjustment. And they hear appeals from the planning board, and then I'm not talking about CUPs, but they hear appeals and then they can go straight to circuit court. Another concern I have is on page 2, under definition of county plan. The definition cited in our ordinance that we're asked to pass tonight says the county's comprehensive plan, whether in whole or in part, as adopted by the county planning board, approved by the quorum court. The planning board hasn't adopted this, so they haven't adopted anything about this. So either I would think that would cause a problem. Finally, the proposed ordinance contains what is commonly known as a repealer clause, Article 3 of the proposed ordinance. That's a clause that invalidating the current zoning ordinance, Washington County Code 1320.07. A successful legal challenge to the proposed ordinance would likely leave unincorporated Washington County with no zoning at all. Those are my reasons that I will be voting no, and thank you.
I feel obligated to supplement the record. I have never wanted to solely ride roughshod over this process. If there's a process that she has an issue with, that she thinks I'm solely trying to take over, 1, I'd like to be asked, and 2, I'd like to have an amendment up for a vote. I have no issue with this. We've got to get off this obsession that I want to take over this process. I do not. I don't. Right. I mean, there's places where the Constitution speaks to it. But I'm wanting this to be as collaborative as anybody wants it to be. We've got to quit agonizing over this. If you have changes, bring the amendment. We'll vote on it. You will vote on it. I have no vote on this board. Justice Rivera-Lopez?
Thank you, Judge. I would like to bring to the point what this is about, what I think that everyone has referenced, whether it is for the private sector or for this board. What this does is make a more accessible document. The whole point of this is to be more accessible. Whether you are a developer, a planner, whether you are on this board and seeking to amend or make things more clear, what we have in front of us is just something that has everything that we've codified, and we do not have to go look in multiple places to go and get that information. So nothing new is being added to the books. Well, there are, with the exceptions of what has been discussed here right now. What this is about is accessibility. And as we can better access that information, I think we can make better informed decisions. If this is a pain for people, for developers, it's also a pain for us. I don't think that anyone is making any qualms about that. What I do believe, however, is that as we make this more accessible, I think everyone on this board has said that this is not a finished document. This is not how we would like this to end. But what we have is to have something that is accessible, that people can read, that people can look at, that, as Justice runs, and I apologize for addressing somebody on the court, but we need something that we can reference easily. We need something that we can look at and then make decisions upon. And I do not know of anyone, that's going to go and click all these links to go and make informed decisions. That's the reality of the situation. I am in favor of having an organized document, absolutely, but we need a document with everything in place so that we can then make those changes. And for that reason, I am in favor of moving this forward. Thank you.
Justice Coger.
Thank you, Judge. I forgot one thing I wanted to just address. When we're talking about codification, the ordinances, that's done every 5 years. So regardless of whether or not we pass this right now, it's not going to come up for, another 3 years? I think that's correct.
The AAC is very open to us. They'll do it 5 years unless we ask specially. So did you ask that of the AAC before you brought it up? Did you ask them before you brought that up? Because they've been very open to us about helping us.
Well, no, I'm just going by what there's a statute that says they're codified every 5 years.
I thought you had some special knowledge. Justice Rios Stafford?
Thank you, Judge. I just wanted to point out two things. Under the both types of appeals that we have, the land development appeals and the zoning and CUP appeals, the last stop is not in this room. The last stop is the circuit court under state law. The circuit court is the place that when people have run out of appeals with the quorum court, the county judge, however we've decided to do it, that's not the final word. The final word is with the circuit court. And nothing we do can change that because that's state law. The second thing is, JP Lopez brought something up that I agree with and forgot to mention. I don't see this as the final, okay, we're going to we've been going round and round in this for 17 months, and we need to pull the trigger at some point. But I don't see this as the end of our process of improving our planning and zoning codes. I think we need to take another look at some point at stuff like mixed-use zoning, where we have some commercial at the major intersections of some state highways, something like that, because the way our county is growing, we are going to need something like that. And so we're going to need to look at stuff like that. I've heard good suggestions from folks about improving our conditional use permit process. Those deserve a look. But I don't think that we should be boiling the ocean and try and change everything at once and endlessly amending this, because we're never going to get it passed. Once we get something passed and on the books, then we can take little surgical targeted pieces bit by bit and improve it and amend it once we actually have something passed into law. But if we keep going round and round as part of this process, we're never going to get it across the finish line. Thank you.
Justice Pond?
Yes, thank you. I'm having a little difficulty here understanding why Association of Counties is going to, if we would vote to pass this, they're going to do something to simplify it. Wouldn't help us do something to simplify it so we could see what we were actually voting on. And we've got people talking about, well, I've got problems with this and I've got problems with that, but let's go ahead and pass it and then we'll fix it later. And that's something to be cautious about. Thank you.
Justice Ecke?
Yes, thank you, Judge.
I'm sorry.
Call the question.
Okay.
Thank you, sir.
Public comments on item 9.1. I have a motion to pass item 9.1 by Justice Lyons, a second by Justice Ecke. You're going to have to push that button on the bottom right.
Off. Can you hear me? I read the whole thing more than once, and I really do appreciate the efforts to consolidate all of those references because it's a mess. And that I do acknowledge that everything Ms. Rio Stafford said, I believe that she's correct. And that you can make a choice. I mean, I think you definitely need to fix that cup process. Don't you agree? We're just tired of this, and it would be really nice if the cup process was specific and that it required you to comply with the Arkansas Code as a condition of being granted your conditional use permit, so that you don't leave those things hanging. And, you know, to create the problems of people who think, it's just like getting a building permit. You get the building permit, the inspector comes, you're in compliance. And that's the major issue, is that you have a terrific opportunity to fix that. You can say no sound over this, you know, no non-agricultural amplified sound. And that would address a lot of concerns about these gathering places. Nothing over 80 decibels and nothing after 11 o'clock at night. That's the main point. That's the main opportunity that you have. And that going forward, I'm really encouraged to see that you're participating in the regional planning effort, because there are forces greater than the county that need to be considered when we make our plan, and that there are other uses besides commercial uses. There's mixed uses and things that can actually move Washington County to a more visionary position about how to handle growth. There's, you know, I understand why you need to pass it now so that you can just move forward. But I think it would be nice if the motion included a commitment to fix these things that need to be fixed, such as the cup, fine-tuning the judge's authority on Section 4. As I know it's been done that way, but it is in violation of state statutes. Why keep that in there when it's only been used once? At any rate, that's the summary, and thank you for your efforts.
Thank you. Public comments.
Kenneth Lovett, Fayetteville. Integrity and respect means a lot for a public servant, and that's what you are as a servant. You keep talking about your neighbors. You're their servant to get done what they need to be done. This, just throwing it out here like this, it needs to be cleaned up before it's approved. You don't know and you say we're going to fix it later. There needs to be an amendment or something tonight that includes this information where it's proper and within the law. Why would you approve anything that has something in it that's against the law, that makes you wrong? Thank you.
Public comments.
Sherry Main, 15451 Riches Road, Fayetteville. I have a lot to say, and I'm not going to be able to say it in 3 minutes, but I wanted to bring this point up first. What happened with the planning board tonight was the same as the ordinance 2025-00040 the judge presented in June of 2025, which failed by this body. Why was an ordinance needed to terminate the current county planning board and establish a new county planning board under the new law? Why did it need an ordinance to abolish on 8/4/2025 and create a new planning board on 8/5/2025? At the time, an ordinance we thought was needed. Apparently, an ordinance was not needed, because tonight the judge didn't need an ordinance, and he just did what he wanted to do in the previous ordinance in June that y'all didn't pass. So think about that for a minute. Okay. Things are happening quick here. On the planning board, the proposed planning ordinance, all of those things that J.P. Lyons put up there, all those amendments and all those things that you click on and an amendment comes up are important amendments. I have researched every single one of those amendments. I was here probably when those amendments passed. I've been following county planning since 2004, okay? And it hasn't gotten any better. This proposed ordinance of planning and zoning has not got any better. It doesn't address the issues we had in 2004. It doesn't address any of the issues I had here in 2002. They're still going on. Still got rogue dirt pits. Still got people not following the rules. Still don't know what's agriculture. Still don't know what's deemed a surface mine or a rock quarry. If it's going to be agricultural pasture, well, it's agricultural. This new proposed ordinance does not explain any of that. Still just muddy water. Doesn't explain agritourism. What is that? Wind farms, agricultural farm related, needs to be less subjective. We can't just clear the land and then grow wheat and say we're agricultural. And the majority of those amendments that were passed are amendments during the 2006, 2007, 2008, and 2009, correcting the mistakes in the original passed zoning ordinance of 2006. So I'm here to tell you, I was there. I seen it happen, and the corrections to be made to this one that you're planning on passing tonight of 199 pages will have amendments, corrections, in this administration or the next one. It's going to be just as fuzzy.
Thank you, Ms. Manning.
As the
That's
one
your
we
time.
have now. Thank
Public
you.
comments.
Stephanie Foster, Fayetteville. I can see both sides of what you guys are dealing with. What do they say? The perfect is the enemy of the good. Well, you're not going to get it perfect. We definitely want it good, though, and that's what you guys have to decide, is this good enough? You know, everybody sees it through their own lens. My lens right now, because it's a real stressor in my life, is the fines for violations for people under appeal for a CUP. We've been dealing for 7 years with a mining company operating illegally. But I will tell you this, $1,000 a day will not stop this activity. That's maybe 2 dump trucks. The summer of 2023, they were running 60 trucks a day. So, you know, that's maybe two trucks. That's not even 1% of the money they're bringing in from their illegal activity. So that's one thing that is not good and is not perfect, is if you are going to, you know, if you are going to pass it as is, I would ask you to immediately try to make an amendment and get that fine up where it actually makes a difference, because we can't do anything but breathe the dust and pray that nobody gets hit on our narrow, windy road by 60, 70 dump trucks a day. So let's make it as good as we can when you guys pass it. Thank you.
Thank you. Public comments.
Hi, Bryson Austin, still live in Fayetteville. I appreciate the Justinian effort of trying to consolidate all of these rules. I'm a person that spent a lifetime almost in student government, and I do know how hard it is to read through documents like this and make sure that you're following everything, and for developers it can be quite tough. So on the one side, the consolidation is a good thing. On the other hand, I take Justice Koger's point that there is a bit of a factor of once you pass something and codify it, you don't always want to go back to it. That happened with legislation in years past at all levels of government, so I understand having a hesitation that those things will be fixed if you go ahead and pass them now. I don't know how I would vote, to be honest, so I don't really have a recommendation for you. But what I will say is my great-grandmother was one of the closest people to me in my life. I lived with her for a time, and she grew up as a sharecropper in southern Arkansas, and I'm very fortunate to have been able to know her. And she was one of the people that really taught me how to be professional and how to be respectful. And she was a funny woman. I don't think that the women in her life always treated her fairly. So she didn't really like women, and she made that known, that she really loved men. She liked to interact with men. But one thing that she always said was when we had family dinner at her house after a prayer, she said, after you thank the Lord, you cannot disrespect anyone in the household. And I always felt that that was strengthened by kind of our values of being from Arkansas, of you respect women first and foremost, and you respect your elders. And someone earlier made a comment about particularly this court being respectful. And I didn't know, this is my first time attending, so I didn't know going into it what it would look like. But I would just remind you, please, out of respect for the office, and after you thank the country and you thank the Lord, be mindful of how you speak to each other and try not to get personal. I know that tensions are high. Personally, I had a trying day at work. I started a new project. It's grating on my nerves, but I'm getting it done, and it will be we'll be better for it on the other end. But yeah, just be patient with one another and try not to get too into the weeds on this type of thing. So yeah, thank you.
Thank you. Our public comment time has expired. I have a motion to pass item 9.1. 3 minutes. I have a motion to suspend the rules by Justice Rios Stafford for 3 minutes. Do I have a second? Second by Justice Lyons. All those in favor?
As long as I've waited here. Okay, I'm LaJoyce Heflin Thomas Duncan, and I live at 14140 Heflin Thomas Road in Low Gap, West Fork, Arkansas. I came here, and I know that it is a hard decision for you all, but it's a big decision for me as a property owner, as a farm operating business. We have, my daughter and I, my children, we have 240 acres out there, and I want to continue it as ag business operation. I'm concerned, but I think you answered my question, that the zoning won't be done for another 3 years. I'm concerned about the zoning. I want to leave it as ag business. And I want to know where it includes me, what I could do to say most of this is the same, but where are the changes in the thing that tells me that it won't change? It's not? Good. Well, it makes me feel better because I've been here, I'm raised in Arkansas, Fayetteville, 86 years, be 87 pretty soon. We've owned this farm since I was 80 years old. So it's going to continue. It's already in a trust, and as far as I know, down the road, it's going to stay that way. We're not going to have very many farms down the road, and it's going to, as far as I'm concerned, my kids are going to take over it, and it'll continue after I'm gone. Thank you, and good luck on your voting.
What an appropriate testimony for County Fair Week. I appreciate you so much. I said, what an appropriate testimony for the County Fair Week. Thank you so much, Ms. Duncan.
Right.
Yep.
I would be there if I was able, but I'm not.
I hear that. I have a motion to pass item 9.1 by Justice Lyons, a second by Justice Ecke. Mr. Allen, can you please call a roll?
Justice Coger? No. Justice Dennis? Yes. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? No. Justice Ricker? Yes. Justice Pond? No. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? No. Justice Rivera Lopez? Yes. Justice Lyons? Yes. Justice Ecke? Yes. Justice Dean? No. Justice Washington? Yes.
Item number 9 passes. Thank you for passing that so that we can continue our work to the Quorum Court. Item number 10, Counselor, will you read that by title only? Good.
Item 10 is an ordinance amending the membership of the Washington County Planning Board.
This item's on second reading. Justice Rios Stafford?
Thank you, Judge. It seems that at the beginning of this meeting, the Quorum Court cleared up the reasons for bringing this ordinance forward in the first place. But I would like to just leave this on the second reading and bring it back so that I can get some feedback from the public on this.
Thank you, Justice Rios Stafford. Nope, it will stay on second reading. It will be third reading next month, and we'll move on to item number 11. I'm sorry, it's the consent agenda. Counselor, will you read the consent agenda by title only?
Item 11.1 is an ordinance anticipating additional revenue of $31,167 in the JDC Grant Fund and appropriating $31,167 from the JDC Grant Fund to the Juvenile Detention Center Grant in Aid 2025-2026 budget for 2025. Item 11.2 is an ordinance amending the IT budget for 2025 and for other matters pertaining thereto. Item 11.3 is an ordinance amending the DEM Grant Fund budget for 2025 to correct an error and for other matters pertaining thereto. Item 11.4 is an ordinance amending the Juvenile Detention Center budget for 2025 and for other matters pertaining thereto. Item 5 is an ordinance recognizing and appropriating additional revenue of $6,000 in the AOC Juvenile Court Division 8 Grant Fund for 2025. Item 11.6 is an ordinance amending the CSU Fund budget for 2025 to correct an error and for other matters pertaining thereto.
Justice Lyons.
I move we pass the consent agenda.
I have a motion to pass the consent agenda by Justice Lyons. I have a second by Justice Dean. Is there any public comments on the consent agenda? Seeing none, Mr. Allen, will you please call a roll?
Justice Coger? Yes. Justice Dennis? Yes. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes. Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? Yes.
The consent agenda passes. With that, we had a Finance and Budget Committee meeting. The committee report is in your packet, and with that, we'll be adjourned.